Hi, my name is Erich Straub, and I'm an attorney with Straub Immigration. And in this video, we're going to talk about the Provisional Waiver Program, or as it is also known, the Stateside Waiver Program. This is a very hot topic in immigration because on January 3rd, 2013, the government released the final rules for this new program. Now, the program applies primarily to spouses of United States citizens who are applying for a green card or permanent residence through consular processing. The program is very significant because it should decrease the amount of time that the spouse has to be separated from his or her family. The government will begin accepting applications on March 4th, 2013. In this video, I'm going to explain who is eligible for the program and how an attorney can give you an advantage in the application process. Now, I use the term consular processing, and that's a legal term, so let's talk about what that means. Consular processing is when a person must go to a U.S. consulate in their home country to obtain a visa. Now, if you were lawfully admitted to the United States, then you don't need to go through consular processing, and you are eligible to apply for a green card or permanent residency here. You may also be eligible to complete the process in the U.S. if you fall under a provision of law known as 245I. Now, if you think you may fall into either one of these categories, we have an earlier video on our website about marriage-based visas, or you can call our office and talk to an attorney about whether you may be eligible. So again, this video is about provisional waivers, and we should break down that term a little bit. So let's talk about what a waiver is first. Why do you need a waiver for consular processing? In many instances, it's because your spouse entered the U.S. without a visa. If your spouse has been present in the U.S. without a visa, that time is considered unlawful presence. Now, again, unlawful presence is a very technical legal term, and actually, there's a 51-page memo from U.S. Citizenship and Immigration Service on what it means. Now, there's no way that we can break down that 51-page memo in this video, and you really need to talk to an immigration attorney to determine whether you have unlawful presence and what the effect might be on your case. But practically speaking, if your spouse has a period of unlawful presence that is more than 180 days, he or she must wait between 3 to 10 years outside of the U.S. before they can be granted a visa. A waiver can eliminate this waiting period as long as your spouse can show extreme hardship to a relative. And in most cases, that relative is going to be the husband or wife who is a U.S. citizen. So now you understand what a waiver is. What does provisional mean? Well, normally, an immigrant spouse must travel to his or her home country before applying for the waiver. The provisional process is new, and it allows for the spouse to apply for the waiver while he or she is still in the United States. The reason that this is so important, again, is because it can significantly reduce the time that the spouse is separated from his or her family. Your spouse is still going to have to return to his or her home country, but the waiver will already be decided, and it should shorten the process. Now, before we go any further, there's something very important that I need to tell you about this video, and that is, it is for informational purposes only. By watching this video, you do not have an attorney-client relationship with Straub Immigration. If you want to have an attorney-client relationship with us, then you certainly can call us, and we would need to know the facts and circumstances of your specific case. At Straub Immigration, we have clients from across the nation, and in fact, clients who live all over the world. If you call us, we can help you with this process. So let's talk about who is eligible for the provisional waiver process. The first requirement is that in most cases, the applicant has to be the spouse of a United States citizen or the child of a United States citizen who is under the age of 21 years. The applicant also must have a petition for permanent residence approved. Now, this is known as a Form I-130 and is the first part of the process. All of the visa fees must be paid, and the applicant must be physically present in the United States when the waiver is filed. The applicant also must be at least 17 years old. And finally, the most important requirement to be aware of is that a provisional waiver only applies if you have unlawful presence. If there is another legal reason why your visa can be denied, then you are not eligible for the program. And some of those other legal reasons can be criminal conduct or some type of fraud or misrepresentation in the immigration system. So let's talk about who's not eligible for the Provisional Waiver program. And we've already talked about one group of people, and that is people who have certain criminal convictions or who have fraud or misrepresentation in the immigration process. Since the waiver only applies to family members of United States citizens, if you are a family member of a lawful permanent resident, you're not going to be eligible for the provisional program. If you have already started this process and you had an interview scheduled with your consulate on or before January 3rd, 2013, you're also not going to be eligible for the provisional program. Finally, if you're in deportation proceedings, you may be eligible for this program, but you're going to have to get the government to agree to administratively close your case. If you have a prior deportation order, you're first going to have to get your case reopened and then have it administratively closed by the government. So how can an attorney help you in this process? Well, first of all, an attorney can help you determine whether you're eligible for the Provisional Waiver program and explain the potential risks of applying specific to your case. It's important to emphasize that the government has stated if you're denied the provisional waiver, you can be placed into deportation proceedings. So the risks can be significant. An attorney can also assist you if your case has a particular complication, and we've talked about some of those complications. Those can be a criminal history or some type of fraud, misrepresentation, or other complicating factor in your immigration history. It might be that you were in deportation proceedings and have a deportation order, or you're currently in deportation proceedings. If you fall into any one of these categories, it's possible that you may be ineligible for the provisional waiver, but not in every case. So, if you believe that you are in one of these categories, you need to talk to an attorney who can assess the specific facts and circumstances of your situation. And finally, an attorney can help you tell your story in a way that gives you the best chance of getting your waiver approved. Remember, earlier we talked about how in order to get the waiver approved, you have to show extreme hardship. And you might assume a long separation from your family would be enough to establish that. However, the law actually says that it has to be more. So that's why it's really important to have an attorney so that you can show that you meet this higher standard. Here at Straub Immigration, we really help our clients tell their unique story of hardship and document it. And given our expertise, we can give you the best chance at minimizing a long separation from your spouse or family. At Straub Immigration, we have a reputation for achieving results in even the most complicated cases. We represent clients from across the nation and around the world. So if your case is straightforward, or if it's one of those complicated ones, no matter where you live, I welcome the opportunity to represent you.